Army Sergeant Bo Bergdahl will face a court-martial on charges of desertion and misbehavior before the enemy. He's the soldier who wandered away from his unit in Afghanistan and was held captive by the Taliban for 5 years. Now, desertion can carry a death penalty, as can the other charge, but the military hasn't executed anyone for 50 years. So what can we expect from Bergdahl's trial? For some answers, we turn to Brian Bouffard. He's a former Navy JAG and now a military defense attorney. Brian, good morning. Great to have you back.
Tom, good morning. Thanks for having me.
All right, so now that the charges have been filed, it's been a long time in coming. What is the next step in this whole affair?
The next step here is going to be an Article 32 investigation. And, we've been hearing the word investigation bandied about in this case. And, your listeners might wonder, well, why do we need another one? It's more of a hearing than an investigation. It looks, if you're sitting there watching it, it looks very much like a session of court. But the purpose of it is equivalent to the civilian grand jury process, and it will be up to an investigating officer, the Article 32 officer, to hear some evidence and determine whether or not the government has probable cause to proceed to trial, and it will make recommendations as to what trial is appropriate.
So it seems like just the bare facts of the case would mitigate in favor of a trial without saying whether we know exactly what happened.
I think so, too. I mean, these cases are as far as probable cause is concerned, they tend to be pretty open and shut. You were either where you were supposed to be or you weren't. You either had permission to be gone or you didn't. Here we have ample evidence of where he was.
And so I was going to say, when that Article 32 investigation is done, who decides? Is it the presiding judge, or is there a panel?
Well, the presiding officer. He's not a judge, and in the Army, he need not even be a lawyer. But he will make a determination whether or not there is that bare minimum standard of evidence to go forward. It's an important protection for service members in lots of cases, just like grand juries are important in the civilian world. But in the military, his recommendations are purely advisory. So bottom line is, right now, as we all sit here today, if the government wants this thing to go to a general court-martial, that's where it's going to go. This is just a hoop that they have to jump through.
And so how long is that likely to take, and when and how far after that decision would the actual court-martial begin?
Oftentimes, an Article 32, let's say it happens on day one, we're looking at a decision to send a case to court-martial probably around day 30 or day 45. So it's not going to be very long. Once it does get referred to a trial after the 32, it'll be in the hands of a military judge, and it will proceed from that point in a very orderly fashion and in a fairly quick fashion from that point.
And presuming there is a court-martial, would the judge preside over the verdict, or would there also be a panel to decide in the equivalent of a jury?
Let's assume he gets referred to a court-martial. It's going to be Sergeant Bergdahl's own decision what type of court-martial he would like to have his case heard by. He's going to have one of three choices. He can either have it heard by a judge alone, a military judge alone, who would decide guilt or innocence, and if he's convicted, also a sentence. He could elect to be tried by a panel composed of all officers, and finally he could elect to be tried by a panel of officers, but with at least 1/3 enlisted representation. So that choice, unlike in civilian trials, that choice is exclusively up to the accused.
And knowing what we know about this case, I'm guessing he would probably choose either all officers or just the judge, because there have been so many other service members at his rank that have spoken out against him. He may wonder whether any of them would be able to be objective in this case after so much information has been getting out for the past year and a half.
You always wonder that in lots of different kinds of cases, and certainly it's very evidence-driven. As a defense attorney myself, I'm advising my client even on issues of, hey, I know this judge, here's his personality, so a lot of factors go into that decision, and many of those factors really nobody knows at this point. Nobody knows who the judge is going to be. Nobody knows what types of court members they're likely to select. So that's a decision that is not going to be made until fairly late in the game.
We're speaking with Brian Bouffard. He's a military defense counsel and former Navy JAG officer. And just looking at what you've read, I mean, how strong do you think the case is against Bergdahl?
Well, it's interesting. We've been speculating for many months, obviously, on this case, not knowing what's happening, not knowing where it's going. I mean, even starting off with Susan Rice saying that he served with honor and distinction. Clearly clearly what I'm looking at on the charge sheet doesn't meet that standard. But what is a little bit new here is that they have gone beyond mere desertion, and they've also charged Article 99, which is misbehavior before the enemy. And they're saying that he committed misconduct in a war zone in the presence or before the enemy, in that he left his post and he left without authority, and interestingly, that he wrongfully caused search and recovery operations. So the fact that the government has alleged that in the specification indicates that they're going to make a big issue, as they should, over the men and women who went and searched for him and were injured and in some cases killed.
Yeah, causes false alarms in any command unit or place under control of the armed forces is one of the charges that constitutes misbehavior, I guess, or just simply runs away.
But misbehavior before the enemy is actually a catch-all kind of statute. It covers a lot of different things. Even running away can be misbehavior. Quitting your place of duty to plunder or pillage, casting away your arms or ammunition, cowardly conduct. Lots of different specifics that you can charge under that article. And one of them, as the government has charged in this case, is through disobedience, neglect, or intentional misconduct endangers the safety of any command, unit, place, or military property.
So
that's
really
that he did here.
Yeah, so the standard, I guess, or the reason for misbehavior before the enemy, the difference here is you can desert from a civilian zone, say the United States, but when you are in enemy territory in this case, or you're overseas fighting an enemy, that makes the charge of desertion much more perilous, I guess.
Well, that's true, and I think that's also going to play into that first charge. But remember, he's actually charged with two different offenses, one of which is desertion, and then the other completely separate offense is, hey, under the circumstances that you left, you're committing misbehavior before the enemy, and you wrongfully caused people to go out and have to look for you and put themselves, clearly in harm's way.
Yeah, so his defense attorney is saying, I've read this in a couple of different news accounts, that, well, he was actually looking for an officer to complain to when he was nabbed by the Taliban, and then he can also claim that his treatment while in captivity would show that he wasn't on their side, I guess. And so it's possible, I guess, if the defense can convince the court of that he could be acquitted on one charge but still be convicted on the other.
Absolutely. And the other thing that the government did in this case that I think is a pretty smart move on their part, they certainly could have charged him with aiding the enemy. That's another article that really encompasses somebody going over and attempting to help them and harm our folks. And they didn't charge that, and I think that's probably a pretty smart move because there's probably not a ton of evidence to show specifically how or if he aided them, if he gave them information. Let's say about the safety and perimeter of the forward operating post. So it's a tight-looking charge sheet. The government certainly has a big job to do, but it looks like a job that, at least based on what we've all heard, it seems like something that they can accomplish.
Now, that Article 99, misbehavior before the enemy, does carry potentially the death penalty. Desertion, I guess, can in some cases. And they also, I guess the next step down from that is life imprisonment. How likely, even in a conviction on both charges, is he likely to get life in prison? Because I'm presuming they would not impose the death penalty. Well,
correct. And the death penalty is only an authorized punishment for these offenses, quote, in time of war. And you might be thinking, well, obviously we're at war. We've been at war since, shortly after 9/11. It requires a declared war by Congress, which we haven't had in decades and decades. So the trigger of time of war is not going to take effect, which means that the maximum punishment that he could be facing would be 5 years on the desertion, but life in prison on the misbehavior charge. So the stakes are extremely high, even with the death penalty off the table.
Well, then, so you're saying another probably 30 days we would know whether there's going to be a trial, and so right now everything's on ice for the time being until that equivalent of the grand jury gets underway?
Right. 30 days is a little soon from this point because I'm not sure, as I sit here, when the Article 32 is scheduled. That can also be delayed for various purposes. So I think the takeaway point, though, is all of the delay that we've had up to this point has really been pretty egregious, in my opinion. That period of unexplained delay is just about over.
And is there any chance, or is this possible, for the Army to remand him to his family while they prepare for possible trial?
No, he's still on active duty. He still has jobs to do. He's doing administrative work down at Fort Sam Houston in Texas. So he's going to be working his job. They have not put him in pretrial confinement. So he's just like in the civilian world, he would be like a person awaiting trial who's made his bond and is out doing whatever it is he would normally do.
So is he free to come and go from the base as some service members are?
I don't believe that he's on any kind of restriction. I could be mistaken about that, but normally, whether you're pending trial or not, if you're not on restriction for any reason, you're free to have normal liberty.
All right. Brian Bouffard is a former Navy JAG and now a military defense attorney. Thanks so much for joining us.
Anytime, Tom. Take care.